Good morning, good afternoon, and good evening, depending on where you are. Welcome to all of you today's webinar on China. We have many previous participants amongst the audience and even more new ones. So I'm Stewart Dresner, founder and chief executive of Privacy Laws and Business. And it's a pleasure to have you joining us from 34 countries around the world, stretching from Mexico, Chile, Brazil and Canada in the US in the West, through 18 countries in Europe, and in the Middle East, we've got in Africa, we've got Israel, the United Arab Emirates, South Africa, and 8 countries in Asia, including China, of course. Last week, we had 4 online events on new and updated privacy laws in Asia, with sessions presented by Privacy Laws and Business's Asia Pacific editor, Professor Graham Greenleaf, and 2 roundtables. The webinar videos will remain available to everyone who registers. Today, we will bring you as much information as we can in 75 minutes on doing business in China, how to navigate Chinese data privacy and cyber laws. Privacy Laws and Business has organized this webinar in cooperation with our sponsors, Dentons, the leading international law firm. And I developed this event together with Nick Graham, partner at Dentons in London, who is unable to be with us today. Dentons is the world's largest law firm with 12,000 lawyers in 200 plus locations in more than 80 countries. Now, Privacy Laws and Business is an information company specializing in this field, and we are now in our 35th law year. PL&B International Report is published in paper, PDF, and online formats, and it looks like this in the paper version. In the February edition, we published tables on 145 national data privacy laws and 23 bills. In the April edition, we had articles on Singapore and Vietnam and many other countries, and we always cover practical management issues. Full information on both PL&B International and United Kingdom reports are on our website. We've released 14 podcasts under the name Privacy Paths, and the most recent one is on AdTech. Our podcasts are available on our website at privacylaws.com/podcast, or the usual place you get your podcasts. I should say the recording of the video of this session will be available to you from tomorrow, and we will tell you. If you have any questions for the speakers, please type them in the Q&A section, which you'll find at the right of your screen. Now, you can also see on the screen Laura Lincoln, and she is editor of PL&B UK and International Reports, and we've worked together many years, and she will watch the questions as they come in and respond to you, put them to the speakers at the right time. Don't wait until the last few moments of the session. Laura and I visited Hong Kong for the Privacy Commissioner's annual conference there in 2017. From Hong Kong, I traveled to Macau, where I visited the Office for Personal Data Protection. There I discovered something. I was very surprised. I discovered that Macau's data protection law, a data protection authority, translates many European Union documents from English or Portuguese into Chinese, which it sends to the government policymakers in Beijing to help them keep up to date with European developments. I will now introduce our expert and distinguished speakers who you can see on the screen. And their biographies are on our website, but I'm going to give you some information now. We have a balanced speaker team of 2 company lawyers and 2 Dentons lawyers based in China. First of all, Zhen, thank you for joining us. Zhen Liu, General Manager of the Legal Department of Xiaomi in China. And not everyone's heard of your company, although they should have done. The company is very large. The company makes smartphones, mobile apps, laptops, home appliances, or many Internet of Things products. Xiaomi is currently the world's 4th largest smartphone brand and has established the world's largest consumer Internet of Things platform with more than 196 million smart devices connected to this platform. That excludes smartphones and laptops. And currently, Xiaomi products are present in more than 80 countries. So, Shen, you are responsible for the legal and compliance affairs of Xiaomi Corporation, and including privacy compliance, intellectual property management, and dispute resolution in a wide range of jurisdictions across Asia, Europe, and North America. So thank you for joining us today.
Thank you, Stuart. Yeah.
Yeah, if it's probably by the time we've spoken, I refer to 196 million. It's probably 197 million or more Internet of Things devices. We have joining us shortly Peter O'Keefe, and I'm sure he'll appear soon. We have spoken to him slightly early this morning. He's head of legal Asia Pacific for the global footwear company Dr. Martens. And shoes and boots are easier to explain than the smart devices. And he's based in Hong Kong, and he's responsible for overseeing all commercial and corporate matters for Dr. Martens' business in China, Southeast. There you are. You've appeared on the screen, Peter. Hello. Thanks for joining us at precisely the moment where I'm talking about you. And I'm just explaining some of your biography. And you are responsible for business in China, Southeast Asia, and Australia. And you develop and maintain policies and procedures for your company's data protection compliance infrastructure in the Asia Pacific region, and you are responsible for the implementation and support of Dr. Martens' global compliance in the region. Let's turn to Ken Dai. You can see Ken. Hello, yeah, that's right. And you're a partner at Dentons' Shanghai office, and also an adjunct professor at one of the universities in Shanghai, teaching the course covering data protection and privacy and cyber security. You are also a columnist of Forbes China, and since 2012, you've been one of the pioneering lawyers practicing data protection law in China, and you've won several awards. Next to you is your colleague, but we can't see you. Goodall, can you come? Could you, get closer? We can see you. That's right. Yeah, thank you. That's great. So Goodall Feng is an attorney at law and at Dentons in China. And would you tell us your Chinese name, which I can't pronounce, so everyone can hear it?
Sure. My name is Xinqing Feng.
Thank you. Great. And your practice areas, of course, include cybersecurity, data privacy, protection law for companies in many sectors. You're licensed to practice law in China and New York State and have 5 years of practice experience. You mainly assist clients in establishing data and privacy protection compliance systems in China, including drafting, reviewing privacy policies, data compliance policies, data breach response policies, and cross-border data transfers. Well, that's introducing us, PL&B, introducing our speakers. Now onto the subject. Of course, it's well known that China has a population of 1.4 billion people at the last count, and it presents huge opportunities for businesses by way of expansion into Chinese markets. In recent years, China has developed a robust and developing set of data privacy and cybersecurity laws that impact directly on businesses operating in the People's Republic of China. So in this session, we're going to start with a basic guide to Chinese data privacy and cyber laws, and then changes expected in the next 12 months. So let's turn to Ken Dai and Goodall, and you're going to tell us a sort of basic starting guide to Chinese data privacy law. So over to you, please.
Okay, thank you. Thank you, Stewart. It's very good. It's start, and it's good morning, good afternoon, everyone. So I'm Ken Dai from Denton. I'm based in Shanghai. So the first topic will be the basic guide of the legal regime of data protection and privacy is in China. The first one I mention is that, as some of you know, in China, the legal regime regarding this field actually is quite comprehensive, and sometimes we call it fragmented regulation. For example, we have the PRC cybersecurity law, which is come into force on the first day of June 2017.
That will be the. Could you move a little closer to your computer so we can hear you a little better?
Okay.
Thank you.
Okay. So as some as you know, the cybersecurity law is one of the first comprehensive law governing the data protection and cybersecurity law is in China. So that is the basic one. Secondly, we also have some basic law, like we have the civil code, PRC civil code, which come into force on the first day of this year. Under that regulation, we introduced its protection for privacy and personal information as one of the key parts of the personality right. So Moreover, we also have the PRC Consumer Interest Protection Law. That will be contain certain provision regarding the protection of the personal information for the consumer. This law has been introduced in 2015. And more interestingly, in China, we have a very special advertising law. That law is governing some is like the code message and also the send commercial information to the consumer and something like that. They also become one of the key part is for data protection is in China. And also we have the e-commerce law that regarding some personal data protection for the e-commerce. So again, in China, we does not have the unified like the Gdpr in China so far. All the data protection provision are contained in various law and regulation. And more importantly, probably within this year, the PRC Personal Information Protection Law will be released within this year. I would like to call that Personal Information Protection Law. It's somehow like the Chinese Gdpr. They have a more specific provision regarding how to process in the personal data, how to deal with the data breach, how to conduct the so-called data impact assessment, and how to deal with the cross-border data transfer and something like that. So next part we will talk more about that is a proposed important personal information protection law. So in addition to such, we call the general law and regulation. We also have some kind like the sectoral regime or regulation. So I will pass to my colleague Goodall to talk about a little bit the sectoral regulation for the data protection.
Just before you go, I just want to ask you that you talked about PIPL, Protection of Personal Information Law, coming in. Will that replace the sectoral law, consumer law, or will both apply? Both the consumer law, the e-commerce, will they run along in parallel? So will both apply?
Oh, very good point. Is that actually we will not take place of the formal law you just mentioned, the subsidy law and the e-commerce or the consumer interest protection law. They will have more detailed provision and will be become enforced in parallel.
Parallel, great. Okay, that's very clear. So you've got one broad law and the sectoral laws remain. Thank you. Over to Goodall.
Hi. Yeah, just following what Ken has introduced. So because we don't have a unified law, how companies have to do their compliance work so far before the enactment of the Chinese GDPR is actually that there are many sectoral guidelines that fill the gap, and there are national what we call national standards is like UK ICO's guidelines, those kinds of best practice for companies reference. So I would just go with the sectoral rules first, because we don't have a unified law and we don't have a unified data protection agency. So those competent authorities in each sector, they will have the power to promulgate administrative regulations, and they will have their own enforcement activities. Therefore, for companies, they have to pay much attention to what the reality is in their own sector. So I will just give two examples of sectors which place data security as a top priority. The first is life science. I think 1 or 2 years ago, we had enforcement cases where the competent authority has penalized companies for cross-border data transfer of genetic data, and that's very high-profile cases. And another sector is finance, and because in China, it's so common that people use mobile payment and we use banking apps. And it's become increasingly important for these financial institutions to pay attention to their data protection. And I believe those the finance sector the authority has very frequent enforcement activities in this area. Like from time to time, we can hear cases of how they penalize banks who disclose their clients' information improperly. And in addition to the sectoral guidelines, we also have what we call national standards. It's like I think UK's ICO has many guidelines that's pretty much like our standards. But what's more important for the standards in China is that because we don't have GDPR so far, we have this fragmented legislation. But for companies, it's not easy to know that like general data protection obligations, how they can apply that in reality. So these standards give them a lot of practical guidance and reference, and that's how most companies, most our clients work out in reality. Yeah.
Okay, so you've got the advantage of having sectoral supervision is that those supervisory bodies understand their sector very well, and the disadvantage is that there is a lack of coordination, I suppose, some lack of coordination between the different supervisory bodies. So, yeah, so the European model has some advantages and there's some consistency. On the other hand, some disadvantages because one body cannot be expert in absolutely everything, particularly for the smaller supervisory bodies. So no one is saying that the European model is better. It's just they're different. The European model and the Chinese model are different. And you mentioned the standards, and I expect that standards have some cultural importance, that companies, they're expected by their customers and the state to follow the standards. Is that right? Do they have some importance in the mindset of customers, consumers?
Yeah, I can give you an example. Like what I'll call it the most important standard in China is called PISS. It's Personal Information Security Specification. So before we have GDPR, Chinese GDPR, what most companies do in reality is that they look a lot at this standard, because this standard, like, it provides very specific rules on what's the legal basis of collecting information, how to deal with data subjects' rights, those kinds of rules that are very similar to GDPR. Yeah.
Right. Okay. Thank you for that introduction. And Peter, you're on screen now. So do you have any reaction from your experience in working within this framework?
Yes. I think the point is well made that it's incredibly complicated, and there are a number of I think we'd nearly call them quangos in the West, that there's a number of bodies and we're not sure what they do, who they report to, their interrelation, but they seem to have an element of authority and power to impact your business. And so in one sense, you need to be very aware of that. But the GDPR question and the similarities or lack thereof between the Chinese laws on data protection and cybersecurity and GDPR are really the second thing you look at when talking about data protection and cyber in China. The first port of call, and really the starting point, is in complying with any data protection or cyber laws in China. It's not to ensure privacy of consumers or anything like that, is that you adhere to the objectives of the state of the party. There is no privacy in China. If you do business in China, your systems have to be open to let the party have access to them. It's not a question of, if you use a comparison between any of the supervisory authorities in the West and in Europe, they may knock on your door and request information. That doesn't happen in China. They're already in your system as soon as you're in the country, and you have to get comfortable with that being your starting point. And so the bedrock of any compliance is really that it's your system is open to the government having complete access to it. So if your business depends on secrets, if it depends on, you know, a secret recipe or something like that, then, you know, you need to be very careful about going into China, because you won't be able to hide it, or stop them looking at it.
Okay.
Sorry, but then the second point then is the GDPR, which is much more, the similarities between GDPR, which is the second question. And China has made massive steps forward in the last couple of years. The laws are so fragmented and so huge and it's incredibly difficult sometimes to tell the difference between what's a law and what's just a regulation. And even within the sort of the government or the state bodies, they will have their own rules, but then the local bureaus in various different cities will have different interpretations of that. So it's incredibly difficult. And so one of the things I always say to people is you have to get on the ground advice in China very quickly, and you have to get good people. You can't, maybe I'm jumping ahead of things by saying this, but using Western lawyers to interpret Chinese data protection, cybersecurity rules and regulations is nearly a recipe for disaster.
Okay, let's leave it there. Thank you very much for that overview. We understand there's difference between laws and regulations, and enforcement can be different in different regions, so it's a very complex picture. Let's turn our attention to Zhen from Xiaomi. You're based, of course, in China, and you're a Chinese-based company, so you are firmly within the culture. So what could you give us any comments of your experience of dealing with the existing law, sectoral laws, and as you look forward to the new law?
Yeah, I think as Ken has mentioned, for the moment there are two laws in the legislation proceedings, which are the data security law and personal information protection law. And considering these two laws are still at draft form, many things are not very clear so far. Yes, especially there are many vacancies on the cross-border data, cross-border transfer issues, and storage data, personal data storage issues. And also, I think both Peter and Ken mentioned the authority overlapping for the regulatory bodies. I also agree with that. Actually, I think for the moment there are 4 major agencies have authority over cybersecurity or privacy issues, which are Cyberspace Administration of China, which is CAC in short. The other one is the Ministry of Industry and Information Technology, which is MIIT in short. The other 2 are Ministry of Public Security of China and State Administration for Market Regulation. I think for regular initiative supervision affairs, the first 2 agencies are the authorities a local company have to deal with for the most, which are CAC and MIT. But for the Ministry of Public Security of China, is basically in charge of the criminal affairs, and the last one, State Administration for Market Regulation, basically in charge of the consumer complaints related affairs.
Okay, well, thanks. That's very helpful. So you've explained that the system is complex, even for you, a Chinese national working in China, and so how much more so for companies based outside China needing to understand the system. Let's turn back to Ken and Goodall to talk about how you expect the new law to be coming into force in the year ahead.
Yeah, sure. Just as Zhen is mentioned, so China is speeding up the registration process of 2 important laws. One is definitely we call the Chinese Gdpr, Personal Information Protection Law. I would like to make a certain elaboration on several key points. First is regarding the jurisdictional scope. So it's quite similar to GDPR under its proposed regulatory scope. So we also have the similar provision. even it does not have an entity or presence in China, but you is connecting the data or monitor the data of the individual is located in China will be subject to the personal information protection law as well. So likewise is at that occasion, you also have self-slide that is representative for data protection. And secondly, regarding the lawful basis of processing is the personal data, also quite similar to GDPR. The first one definitely is the consent. So the consent we also have some very interesting is future. So in some time we have secured the independent or separate consent. You also grant the data searcher the right to withdraw the consent. Okay, secondly is we have some is lawful basis in some emergent event like the COVID-19. So the everyone is enterprise who deal with the personal data without secure the consent. And it's interestingly, unlike GDPR, we does not have the legitimate interest basis for processing the data. Because so far in China, the public concern still is varying. The high tech or the internet is giant. We try to is abuse of the data in China. So they are very cautious to introduce such we call the lawful basis for legitimate interest. So very interesting. And next one, I want to talk about the cross-border data transfer. That would be one of the top concerns for multinational corporations doing business in China. So under the SOFA draft, so introduce a similar regime compared with GDPR. So under certain situation, we have to conduct so-called security assessment. For example, if your company belongs to the CIIO, Critical Information Infrastructure, or you deal with the personal data reaching a number, so you have to deal with the security assessment. Secondly, we are going to introduce the Chinese version of SCC, Standard Contractual Clause, but still wait how the final version is looked at. So other regime is a certificate of approval of conduct. We also will be fulfill the adequacy protection standard. So finally, I touched upon is the DPO. So under the law also is the mandatory requirement when you is reach a certain condition, you have to set up the DPO and something like that. And other important point, I will pass the ball to Goodall to talk about maybe the penalty and other things, something like that.
Okay, thanks. Okay, so Goodall.
Yeah, I think the penalty is what's the most thing that should bring your attention. It's 5%, right? 5% of the revenue, which will even exceed GDPR. And I think at this moment, we're not sure if it's global revenue or China-wide revenue, but it's not clear yet. So what should be bear in mind is that the legal consequence will be pretty serious, like GDPR in Europe. Mm-hmm.
Okay, so it's a serious piece of law. Yes. Did you want to add something now? Or?
Okay. I also want to. I think Ken didn't introduce the data security law. It's another law that's under deliberation in parallel. And if personal information protection law is easy to understand because it's like GDPR, but data security law, it's it'd be very difficult for me to imagine any law in other jurisdictions that can be compared into. I don't want to overcomplicate that, but just want companies to bear in mind is that, as the name suggests, it's about data security. So it will establish some mechanisms about how you manage your data, about your organizational structure, technical measures that should be placed within the company. There'll be requirements for the companies. And on the other hand, it also touches upon the delicate question of when you should provide data to the government. It also touches upon this requirement, and it also deal with when you can provide data to foreign enforcement authorities. It'll be like a blocking statute. acting against like the Cloud Act in the U.S. For those laws in other jurisdictions that might have extraterritorial power. Yeah, that's what we want to make.
So in the last section, you've explained, Kent explained about there's no provision for lawful basis for processing. There is consent, but people can withdraw consent, so that would make it difficult for companies to operate. No provision for legitimate interest, and there are some things that are not quite clear about international transfers. So for multinational companies, that's quite a problem to have this point in the law which is not quite clear. And maybe even worse, that some of the penalties are not quite clear about how they're going to be applied, that there are penalties, but exactly how they're going to be applied. Will it be a fine, a percentage of your revenue in China, or something else? We don't know. And also a problem about transferring data abroad to other countries, whether to government or to companies. So a lot of questions there. Any comments here from, first of all, Zhen? Would you like to comment on any of how these things are affecting your company and the way you are planning your work?
Yeah, I think for the personal data cross-border transferring matter, for the moment, I think considering the vacancy at the law level, we suggest the companies in China, operates in China, avoid any kind of cross-border transferring for the moment. Because I think, as Ken mentioned, as the personal data, let me see, as the PIPL states that a kind of assessment should be implemented before cross-border transferring, but which agency is responsible for the assessment and the standard of assessment are both not clear for the moment.
Right, so you're recommending, as the law is unclear, you recommend that companies do not transfer personal data abroad, so to be on the safe side. Yes?
Yeah.
And is that
correct?
Switch to, so in terms of your platforms with the Internet of Things, I suppose if you are transferring data, it can be anonymous or pseudonymous. Then maybe the law doesn't apply if you make transfers that cannot be identified to an individual.
Yes, it's a big challenge for us because we have both Chinese users and overseas users. We are trying our best to provide services locally, and we store the Chinese users' data within China, and the overseas users' data mostly at Singapore and US and in other countries. But considering our users may move from country to country, and when this kind of events happen, it's a challenge for us to make sure the data will not violate the provision.
Right.
Yeah.
Okay. So Peter, what about you? You of course for you're a lawyer for a Western company, and you're based in Hong Kong, which is next door to China, and from the People's Republic of China government point of view, China. So what do you do about international data?
Well, just before I address that, Stewart, the one thing to point out is, we've established, or we've spoken about how complex the laws are, but they're also vague, and they're purposely vague, and there's purposely a number of issues which remain to be clarified, and that's really the way they like things in China. So I wouldn't expect great clarity in the years to come. There will always be vagueness written into the statutes and the regulations in China, and the errors that a lot of Western companies make is they see that as an opportunity to interpret the legislation or the regulations in their favor. They might see a gap and they think, okay, we can use that. And so the approach for China must always be the most conservative approach possible. If there's anything vague, err on the side of you cannot do it, you should not do it, which is sort of what Zhen is talking about there. If I can separate out the movement of personal data, for data of your employees, I think that's somewhat permitted. You can work with that. The approach we take is we always house. So we have always placed the primary copies of all data on servers in China. And I think really that needs to be the starting point. If you have servers outside of China and you're trying to move personal data, be it of employees or consumers back and forth, then you could get yourself into issues quite easily. But if your approach is the primary copy of the information is based in China, and then there's some element of being able to move out certain employee data. Now, when it comes to consumer data, that's a different area, and I would agree with your approach there. I think you want to aggregate it or anonymize it, or be very careful about moving personal data of consumers outside of China. I would cancel that.
Right. Okay. So your two main points that I've taken on board is that there are grey areas. There is vagueness in the law, but companies are advised to not try and take advantage of those grey areas, because it's better to be safe rather than suffer those penalties that we've mentioned. And the way that you handle that is to hold a copy of the data in China, and the state will be more confident in what you're doing, and you will have fewer risks by doing that. Okay, sure. All right. Now let's get on to the next point. So what are the main risks for foreign businesses? Is it failure to understand the cultural differences, or trying to, companies often try and enjoy working in grey areas because they can, in Europe and other jurisdictions, particularly in the United States, companies like to take advantage of grey areas and take risks. But have you found from any of your clients, without mentioning names, have they tried to do that in China and then suffered any problems? So this is back to Ken and Goodall. Have you found some foreign companies that have a bigger risk appetite for risk?
Yeah, sure. And maybe is important is the risk regarding data protection when doing business in China. Because in China, in addition to we call the property enforcement, we also have a criminal enforcement for infringing its personal information. So actually, it's several years ago, is a very large multinational in the sector of reliance is engaged on criminal cases. At that case, is the employee of that multinational is purchased personal information from the hospital. So at the end of the day, the corporation is a challenge for criminal infringement on the personal information. And however, finally, the corporation is convinced its authority. They build up the very good data compliance program. So that behavior is attributed to the employee rather than the corporation. So always will be to remind the multinational corporation when do business, the first point is criminal enforcement. And secondly is we have some called the obligation of the network security. That will be also the potential important area for criminal enforcement. So the first one I want to mention is criminal enforcement. Yeah.
Okay, so obviously criminal penalties are risk, and have there been some court cases or tribunal cases involving criminal penalties, whether they resulted in application of those penalties? So is this just something in the law, or can it actually happen? Have company lawyers and company executives actually faced a criminal case, a criminal trial? So is this a thing that's actually happening now, or do you fear it might happen in the future?
will be become more frequently in the future. The case I just mentioned is in 2017. The multinational is successful is made defense. Otherwise, their senior management will be sent to jail. If at the end of the day the corporation is amount to the corporate crime.
Right. So certainly the advice here is clear for foreign companies. You really do need help from Chinese-based lawyers who understand every element of the system and the culture they work within. And you mentioned national security. So Zhen, in your company, I expect your data, as you deal with so much data and you have mobile phones and all this, that you must have more sensitive data than Peter O'Keefe, who his company is dealing with footwear, shoes and boots. I expect that national security is less of an issue there. So let's compare the two. So Zhen, do you find in your work you are actually worried about these national security provisions?
So far, I think we haven't faced any challenges on this matter. Yeah.
All right. So it's potentially, but not actually happened. And so, Peter, if you're dealing with consumer goods here, so you represent all those foreign, as far as we're concerned, foreign companies who are dealing with consumer goods that would not, on the face of it, appear to be anything to do with national security. But is there anything that companies from abroad need to worry about because there could be some aspect of national security which is not obvious to the Western mind?
Yeah, absolutely. Because regardless of what industry you're in, when you go in, the first thought is about national security, because again, it goes back to the underlying principle of data protection or cyber in China, and that's everything has to be open and available for the party. Anything which is anti-China is anti-party, and you just can't have that in China. So the second conversation you have is it GDPR? What do we need to do, et cetera, et cetera. But the first conversation you're always having is, are our systems, are the government or the party going to be happy with the transparency of our systems? Then when you move on to I saw somebody's asked a question there. What's the sort of the big difference between GDPR and in China, and the Chinese version of GDPR and GDPR in the EU? Well, in China, you have the bedrock is the party has to know everything, and then you have the GDPR hybrid, which is somewhat similar. So it is this kind of paradox of GDPR in the EU being based on the principle of privacy, of an individual and company's right to privacy, where you don't have that in China. But the risks for companies coming in is they think, well, I'm a consumer goods company, so clearly we're never going to be dealing with anything to do with anything to do with that will cause a state an issue. So we don't even need to think about that, and that's a mistake that a lot of companies make when they go in. From a consumer point of view, the development of the rights of the consumers in China under data protection and cyber laws is really important, because the Chinese consumers are incredibly sophisticated, and they are much more sophisticated than the Western consumers. They are so considered and selective in their purchase, and their path to purchase has so many different touch points in comparison to the West. And so, where, for example, you might have 20, let's say 10, 15 touch points in a e-com path to purchase in the West, you could have 100 in China. And something like your adherence to data protection principles, transparency in what your information you're going to take from them, what you're going to do with it, and making sure that you are comply with that as you would in the EU for GDPR is really, really important. You are looking as a consumer product in China, you want to ensure that you don't create any area where it couldn't reflect negatively on you. You always want to be visible in the most positive light in China, and the consumers take their privacy very seriously in respect of consumer products. So making sure that you comply with the new regulations and that you're very clear, and as clear as you would be in Europe, on what you want, information you want, and what you want to do is hugely important.
Okay. Now, you have referred to all your data is open to the state or the party. What I don't understand is how that works. Zhen, as you're is closer to the action, could you explain how does the government or the state involve? Are they online? Do they access your systems by the back door, or do they send someone around to see you and talk to you about how the system works? How does the state or the party get to know what is happening in your company?
But actually, for the moment, we haven't received any kind of request from any agency, like planned backdooring our OS or our systems. So far, we haven't received any kind of request. But of course, based on other laws, we received the data requests from different bodies like the courts or the national security agencies. But each request have went through a strict procedure, and we count each request internally. And in the future, we are planning to release a transparency report as Apple has done. And I think so far, based on my experience, the practice in China on this matter is no much different from any other country. I think according to the transparency report released by Apple also received a lot of data requests from different governments, including US government. And so far, I think we're facing similar situations, both in China and outside of China.
Right. So I think the point you make is there is potentially some surveillance, there are potentially some requests, but it's organized within a well-organized framework and companies should be aware if they're doing business in China, this sort of access could happen, but it's not every day, and companies should be aware that such access is possible, but it's not something which is going to happen all the time. Okay. Now, Ken and Goodall, are there further points that you'd like to explain about the PIPL that you have in mind that the audience should know about?
Okay, sure. And the further point is regarding the PIPL is I just mentioned the DPO appointment requirement. So under the proposed PIPL, so we are also introduced the provision is once company is dealing with the data is reached a certain amount, so will be required to set the DPO. But the threshold is so far is unclear. So it's very interesting to wait and see how the Chinese government introduced the threshold and then to set up the benchmark for appointing the DPO. And second item mentioned is data breach. As you know, even so far we have the relevant provision under the Specification law. But if you have occur is a data breach in China, actually so far it does not understand how to make a notification to which authority, how to provide its content and something like that. But under the PIPL, they will set more is detail for how to deal with the data breach. And more importantly, under that so far provision, they set up that immediately, once its data breach occurs, you have to immediately make the notification. So how to interpret the immediate notification obligation be also very top concern. And finally, I want to mention is the DPIA, Data Protection Impact Assessment. So yes, compared with the GDPR, we are going to introduce such regime as well. So when you deal with the sensitive personal in data, or is doing the data reach a number of amount, you have to deal with such application as well. So that's the is other three key things I want to mention is under the proposed PRPL.
Right. Okay. Sorry, Goodall, you about to speak?
Yeah, I think I can add one more point is about data subjects' rights. Basically, PIPL will have the data subjects' rights that GDPR have, except for one, it's the right of portability. We probably will have a right called a right to copy the data, but it's not entirely the same as the portability requirement. But it's not clear yet how it'll be like.
Right. Okay, so in this last section, you've told us about the role of the data protection officer. Not quite clear what the role involves, but I suppose companies should prepare to appoint a person in China who can take on that role, who is preparing for the role. Regarding data breach, the point you made is you need to inform. Now, is it immediately, is it the authorities or the individuals affected, or both?
To the authority. So
and is there a requirement to inform the individuals affected? Say a credit card, loss of credit card data, should a company inform the individuals affected immediately also?
Would be is the similar way.
Yes.
Probably, yeah.
Okay. And also, of course, immediately is certainly a challenge, and sometimes it takes time for a company to know what is the nature of the problem. There might be a loss, but it's not. There may be sometimes an incident. There's a distinction between a data incident and a data loss. In other words, sometimes a company can find that someone from outside has gone in, or a malicious insider has caused trouble, but it's not always clear immediately if the data has gone out of the company. So do you recommend that companies inform the authorities immediately, even though they're not sure if there's actually any loss of data?
Very good point. So the first preliminary question will be once the law is enacted, what situation will amount to data breach? Because you have identified whether it's security event or is the HR data loss, what scenario will amount to data breach? That is so far is unclear. It should be defined maybe by implementing rule, even by some guideline, is by the authority. At that moment, what's identified is your situation amount to data breach. You then to consider whether to have fulfilled the immediate notification is a requirement. Yeah.
Okay, well that's helpful. And Goodall mentioned that there's portability is not there yet, but individuals do have a right to have a copy of the data. Right. Zhen or Peter, do you have any comments on how these new provisions have affected your organizations? Who would like to go first? And Zhen, do you want to go first?
Yeah, I think just one more thing I want to mention. Actually, we can see it's a good sign that in the data security law, there are many provisions restrain the authority of data requests raised by the national security agencies. Like from Article 20 to 24, generally it states that even if a national security agency wants to raise a data request, the request should go through a strict assessment, and the data should be limited to an adequate level. I think it's a good sign that the privacy protection responsibility is not just for the companies, but both for the government.
Right. So a proportionate response to any request for information give only what is the minimum required. You don't have to give more than it is asked for. I understand that. Okay, and Peter, how have these rules affected you? I mean, is your company planning to appoint a data protection officer? Are you prepared for informing the authorities immediately if you should suffer a data breach?
Yeah, well, we haven't a in-country data protection officer in China at the moment. We have a global head of data protection who's joined us, and regional teams which support her. The interesting point, and it'd be interesting to hear what Ken and Goodall think about this, is I think that if you fall foul of the new regulations, I think you're probably, as a company in China, going to hear from the local bureau first, rather than one of the government authorities, if it's not a big breach or data loss or anything like that. And I was just wondering, from Goodall and Ken, would that be a fair enough comment that most likely, if a consumer is unhappy with how you have interpreted or how you're dealing with their personal information, most likely the complaint will come from a local bureau, or do you think it would actually come from one of the more larger state authorities?
That's a good question. China is obviously a huge country, 5 time zones, many languages, and obviously different varieties of even Chinese, obviously Mandarin, Cantonese, and other varieties and other minority languages. So yes, it makes perfect sense for a consumer to inform or complain to a local enforcement body. So is that the way you see it, Ken and Goodall?
Very good point. So far, is even the PL does not release any comments for, but actually, if some is a consumer to access their right, but very interesting, they not go to the authority. They will bring the litigation against the company directly. For example, is in Shanghai or in Hangzhou, to my best knowledge, one consumer is come to one of the internet company to request a copy of their e-commerce transaction data in the last decade. So the company is very concerned, because according to the SOFA law, there's no any cost allocation. So that will encounter a lot of cost. And once this litigation is confirmed by the court, for example, the consumer has such a right to claim for the copy of the data, how many years, so without any cost. So you can imagine in China, even maybe it's 1 million is a consumer to go to that company for such a request. That will be subsidy for the company. So far it's interesting. They not go to the complaint, the authority directly. They bring the litigation before the court.
Right. Okay. Well, certainly in Europe, it's normal for if someone complains to the authorities say go to the company first. If you've got a complaint against the company, go direct to the company, try and resolve the matter, and then come to us later if you can't get satisfaction. And that step process, it makes perfectly good sense. Well, I think we've come to the point where we should open up to questions from the audience. I see various questions have occurred. So various things in the chat. So I asked my colleague Laura to come on screen and tell us which questions or which points we should put to our speakers. So Laura, are you there? Well, I'll start having a look at the questions, but this is, Laura, it's your moment to, you've been reviewing, maybe she's got connection problems. Let's have a look. I'm just looking now at the questions. I see. There's a question about the appointment of a data protection officer. Someone is asking, does that person have to be located in China, or can that person be outside China? Obviously, they have to speak Chinese, so that's well, I assume so. So this is a question often asked in these roundtables or webinars. But what's the answer? So we'll put that to Ken and Goodall. Is there the expectation or requirement that the data protection officer be actually in the People's Republic of China?
Yeah, very good question. Actually, there's no specific requirement for the qualification or the requirement for the location of such DPO. But however, in practice, we understand is the authority will require such person will be located in China, and such person can speak Mandarin, is Chinese as well, because the authority normally is our official language is Chinese. So at the end of the day, that will be the practice. You have to be located in China, you can speak Chinese.
Right. I think that's, I understand that, and that's really the implication of other countries, but China being larger than most of the countries, that makes perfect sense. Laura, okay.
No, sorry, I was able to join us just now. I don't know what went wrong. Anyway, there's quite a few questions. Thank you for everybody who's been putting questions to us. Some of them have already been answered during the talks, but there's quite a lot of interest about government access, and there's a very specific question about government access to systems and international data transfers. So I'm sure most of the audience is very aware of the Schrems decision and the company's obligations to assess countries where they are transferring data to. So how do you see this situation evolving in terms of data transfers from EEA countries and the UK to China? What is the route accessible to companies now? Would we start maybe with Ken and Goodall? Give your legal point of view on this. Is it maybe standard contractual clauses, or what would you advise foreign companies to do?
That would be interesting question in China so far, because under the subsidy law we have Article 37. So if you belong to the critical information infrastructure operator, so you have the obligation to store the data is in China, within China. So that it means your server in China. If you transfer out of China, you have to conduct a security assessment. The reality is that security assessment is not actually is effective or implemented in practice. So some of my clients, if they made the assessment, they belong to the CI operator, they will just store their data is in China. However, if at the end of the day you made the assessment, after assessment, it does not belong to CI operator. When they transfer out of your data outside of China, for example, to UK or EU, for example, your employee data, you just to maybe take the best practice to ensure the data transfer agreement. Quite similar have a provision like the SCC is under the UP. That is so far the general practice of ANCAP. After the effective of the PL I just mentioned, you have to review the cross-border data transfer regime I just mentioned. One is the security regime, the other maybe Chinese version of SCC, and then is certificate. Also maybe some is a proof of conduct, something like that. But I want to mention so far under the draft of the PL, we does not incorporate the BCR. The binding corporate rule will not be work well or work at the end of the day when the law is coming to force. Yeah.
Thank you very much. So, Peter, how do you tackle this question in your company in practice?
Well, I suppose it's important to remember that you can move information in and out of China. There's no you can do that, but with every bit of information you move, there's added risk. And so when you approach data in China, you really have to try and quieten your Western mindset and look at it from the locals, the Chinese, the party, the authorities, their point of view. And you really then take a very conservative approach to what information you move back and forth. If it's critical to your business and there's a business case for it, then I think it's permitted, and I would obviously suggest you get local guidance on that as well before developing any policy. But it's not that we're saying that there's an absolute embargo on movement of information. There's not. You can move information. You just have to be very conservative about what your information. There is no nice to have. It's very much what is absolutely required. If it's necessary to your business, then you ought to be able to, by and large, be able to move it. Again, then when we start looking at vast amounts of consumer data, you're getting into sort of problematic areas then. But I think by and large, if you look at it through the lens of what the rules and the regulations in China are trying to achieve, the decisions become a little bit easier. The problem that, having spoken to people in other companies, encounter is that Westerners approach it from a really Western mindset, and they think it's free movement of data when it's not.
Thank you. And Zhen, do you want to add something? Does your company have data transfers with EU countries?
Actually, not much. Just as I mentioned, I think for the moment, many things are not clear. And I think Ken mentioned the term critical information infrastructure several times. I think actually, according to the cybersecurity law, that term covers a lot of companies provide public services like financial institutions, carriers, and hospitals. Yes, according to the cybersecurity law, it states that for the critical information infrastructure companies to move data out of China should go through an assessment proceeding. But also, according to the Article 30 of cybersecurity law, it says that besides critical information infrastructure companies, other data processor wants to move the data outside of China, needs to wait other agencies to make specific proceeding, which means we're not sure for the moment. So that's why I said, I think most, for the moment, any kind of data transferring outside of China is not safe. If a company wants to do that, I think that company should better seek for the legal advice from a counsel, and that counsel may went to the agency for a specific opinion on the data transfer.
Thank you. So still going back to the Schrems decision, which is concerning government access to national security data. Somebody's asking, if you did get a request from government authorities, what types of investigations are they conducting? Would it be fair to say that these investigations would be for criminal conduct? Does anybody have a comment to offer on this?
Okay, and maybe I can just touch a little bit on this question. Yes, under some government investigation, the authority is like the antitrust is enforcement authority, although other kind of competing authority, they will access the relevant data of a company. So they have such right and power to do that. So the target company maybe have to comply with the such obligation. Also, is look at some questions. If such data is not belong to the company, maybe regarding some client information and data and something like that. So whether you have the obligation to inform your client, that will be is follow case by case or scenario by scenario. Because sometimes if you disclose the investigation to your client to mention they are under investigation, that will be amount to obstruction to the investigation. You don't do that. However, if according some is contractual obligation between the target organization and your client, without any is to reach other obligation, and then you have to inform your client. And there are also a very typical scenario, and maybe not relating to the investigation, and maybe just a common inquiry from the government. For example, like in China, some government may put access to some transportation of data. So sometimes there's not very clear its legal basis. However, if you don't want to grant the asset, you have to think about what is the value is the reason for such a refusal to the asset to the data by the authority. Yeah.
Thank you. And then we have a question addressing the somewhat fragmented legislative framework in China. This person says there is the personal information protection law, the civil code, the cybersecurity law, other laws and regulations on personal information. So should a company put more focus on compliance with the personal information protection law than any of the others, or does it really depend on the case? Do you have something?
Maybe Peter have some observation. How to ensure your business comply with such is somehow complicated is regime in China.
And in practical terms, what happens in your company, Peter? Do you?
Well, that's a really good question, and it sort of highlights the issues in China. The best answer I can give you is work with a really good local lawyer, because they'll tell you what you need to do. It's yes is the short answer. That probably if you to pick one law to comply with any of the others, but you would want to work with a local lawyer in the area in which you're operating. So within the area of the particular bureau that may be knocking on your door if you fall foul of any of the regulations. But it's a great question.
So you all highlighted the fact that there are differences and similarities between the Chinese law and the GDPR. So if you just have to name one top item, what would you say? Zhen, what's your thoughts about this?
I think from the enforcement perspective, there is a significant difference. It seems that for the moment, Chinese agencies put a lot of attention on the permission request of internet services. Like if an app requests permissions from a consumer based on its service, it should comply with the data minimization principle. I think, and in the past months, two agencies has already reported more than 200 apps for a violation of privacy. And the agencies also has demand the marketplace app stores to remove more than 40 apps for the violation of privacy. So I think from enforcement perspective, I think for the moment this is a big difference. And just one advice, considering the generality of the law for the moment, I think the company should pay attention to a standard which we call 35273. That standard is kind of specification which have detailed I think suggestion of how you should control the data and how you should manage the data while providing a service. I think it's a good specification you should take into consideration while doing the compliance work.
And Ken, what would you say is the main difference between the GDPR and the Chinese law?
The main difference, so far is difficult to observe. I just mentioned there are a lot of similarity. I think that is the main difference. I just mentioned the lawful basis for processing is personal data. It maybe is different because it does not have the legitimate interest as the lawful basis. And secondly, is I mentioned is the cross-border data transfer. It does not incorporate the BCR is regime. And finally, is always the penalty. We are 5%. It's even higher than the 4% of GDPR. So I just share such is along the three things. Yeah, maybe from my perspective, it's a big difference.
Thank you. And Peter, do you have a different priority there or similar thoughts?
So I think the question, what are the similarities? Was that what you were asking, Laura?
What is the main difference between the GDPR and the Chinese framework?
Well, the underlying principles of Chinese data protection law and GDPR are fundamentally different. GDPR is based on an individual and company's right to privacy, and that doesn't exist at the base level of privacy and data protection laws in China. The equivalent, what we would call the equivalent GDPR type laws in China in respect of consumers, then that's the second stage, as I was referred to it. Yes, the privacy issues there, and the requirement to be transparency, requirement for transparency and use and purpose of acquiring data. That's where the similarities begin, but that's the second conversation you have about privacy in China.
Thank you. We come to the end of our time now, so thank you very much, and I'll hand you over to Stewart, please.
Thank you, Laura, for getting those many questions, or selecting the many questions for our speakers. Certainly, would each speaker like to name your top point which you should draw to the attention of the audience? Remember, in many countries. I mean, I've made a summary of what I think your main points are, but you should say, and if there's anything left at the end, I'll just say that point as well. So let's start with Zhen. What's your top point of advice for foreign companies doing business in China?
I think for foreign companies should pay attention to the enforcement trend, and also I think, as I mentioned, since many laws are still in legislation proceedings, companies should also keep an eye on the development of the legislation. And also, for the moment, I think for the data generated in China should be stored in China. And also, I think any company should avoid cross-border data transferring for the moment.
Right, thanks very much. That's you've given about 3 or 4 points there, which is great. You've delivered more than I asked. That's fantastic, because now everyone's got a clear idea on that. Note the differences between Western law and Chinese law. Be aware of strong enforcement, and store your copy of your data in China, and watching what's coming up as the laws develop. Peter, do you want to have any additional points?
Yeah, I have a few. I would, with China, you nearly need to start with the end in mind. It's very, the wrong approach to China, to working in China, is that we're going to dip our toe in the market and see how we get on. That's really not the approach you take. You kind of have to commit to China, and therefore you have to invest in your systems up front. China is a fantastic country, but it's a very difficult country to crack. And there's many Western companies delude themselves into thinking that all they need to do is dip the toe in China and they're going to make a lot of money. It's really, really not that simple. So you need to begin with the end in mind, that you're going to commit to China and be there for quite a long time. So therefore you need to invest in proper IT infrastructure in China, get your servers in China, primary copies of the data held in China, get good local advice from Chinese lawyers. You can employ an air gap between your systems so that you can segregate the Chinese system and your global system, because there is, as a Western company, this, you read it everywhere, that the fear of the great firewall going up, where suddenly your Chinese business is disconnected from the rest of the world for a period of time. So you need to prevent against that, and you do that by investing up front in proper systems and support services in China. The final point I would make is that you find, I'd say this as we encountered it recently. We had a company offering us a global system for a particular aspect in HR, and that really doesn't exist anymore. There's no one global system which will work in China and work in the rest of the world. You need to be able to segment your China business from the rest of the world if needs be. Be very wary of companies that tell you that they are 100% compliant in China, because no more than GDPR, it's impossible to be 100% compliant. And if you're going to use software as a services from companies based outside of China, you need to do your own due diligence. You need to do the research yourself and not take it on faith what the vendor is telling you. Even if they tell you that they've got local advice, it'll more likely be a paid for opinion, which tells them that they're compliant. So you need to do your own legwork on that.
Great, Peter. Well, that's many points. Thanks very much. Your companies operating in China need to commit. It's difficult. You need a proper IT system in China. You need to have a gap between your data held in China and the rest of your global system. Be aware of the Great Chinese Firewall. And in HR system, there's no global system that can properly work in accordance with Chinese law. Okay, so let's final advice from Ken and Goodall. Who would like to go first?
Okay, my comment is quite general. So it's for multinational. You could have the grow inside or global vision, but you have the local mindset, have the local intelligence. In the field or the analyst scale of data protection and private cybersecurity in China, it becomes more and more complicated, and inclusion is important. It's bear in mind, understand the game, play the game, and win the game with your local good advice. That's all I want to share with the audience. Any comment, Goodall?
Okay, I could only add one more point. Is still about the fragmenting system. I think we've touched upon briefly on the among the fragmenting system. It's not only about the laws and regulations. It's also about the fragmenting agencies. So in addition to this sectoral competent authorities I have mentioned, also the general enforcement agencies, we have more than one. So like Cyberspace Administration of China, like Public Security Ministry or MIIT, we somehow have touched upon that, but it's just to want the audience to bear in mind that you have to deal with more than one agency, and that's pretty complicated. Mm-hmm.
Great. Okay, so be aware, good what you've said about the sectoral agencies. The enforcement framework is complex, and there's many types of the sectoral agencies. There's local, there's national, and the penalties are there. So it brings us really to the end of our session. We have run over time, but I don't really apologize, because this is a huge country with very different norms and culture, legal culture from Western countries. So I think we've achieved as much as we possibly could in this time. So thanks to our speakers today, Zhen, Peter O'Keefe, Ken Dyer and Goodall Feng, and of course my colleague Laura. We need to thank our sponsors and co-organizers, Dentons, and certainly we'd like your feedback. We'd like to know, do you want more information on specific points about China? Thank you. I see a lot of thumbs up there coming up through the screen. That's very encouraging, heartwarming, I should say, for us. Thank you. And also let us know if you'd like to hear about other countries. We've run sessions last week on the Asia Pacific region, the Asian region rather, and before that we've had sessions on Africa. But we'd like to know, where would you like us to cover in future events like this, whether more detail on China or other countries. The next online events are our 6 sessions for our 34th annual international conference, normally held in Cambridge in England, but unfortunately it's online for the 2nd year this year. Setting privacy, winning trust, and we invite you to register. We are publishing just 6 sessions. We have information on our website, and we'll be publishing a fuller program in the next few days. So on behalf of Laura and myself and the PL&B team, I hope you and your families stay in good health as we face the future. We move out of the pandemic. We will keep you informed of future privacy laws and business publications, events, podcasts, and my monthly blogs. We look forward to staying in contact with you. We thank you all, audience, for joining us, and we thank you and say goodbye. With your speakers, like to say goodbye as well.
Bye.
Thank you.
Bye.
Thank you, sir. Great moderator.